Hello, welcome to Marketing 200 International Marketing Week 4 Overview. This week we'll be discussing the contents of Chapter 4, the legal and regulatory variables that will impact any marketing campaign. And again, remember, you're always analyzing how these variables impact your marketing mix. Those are the things you do have control over and that you formulate through your strategy to meet objectives that will help you reach your target market or meet your business objective that's subject to your integrated marketing plan. Before we begin, be mindful of due dates for your assignments. Everybody has at this point been assigned a country presentation. Please make sure you're aware of your due date. The first batch of presentations are due this week. So make sure if yours is due this week that you get that submitted on time. Also, the Global Career Paper, an individual assignment, was due this past week as well. Upcoming, you will have your first group assignment, which is a situation analysis. And also, please remember to stay current with your quizzes and discussions. And on that point, the discussions each week and the readings from the chapter, they all are designed to help you understand what type of analysis is required for all of the assignments above. So when your group gets together to meet about the situation analysis, your integrated marketing plan prompts you as to what to address in your project. You'll also see in each of these assignments that their instructions are pretty simple and straightforward, but if you have any questions about any of these things, please make sure to message me on Canvas ahead of the due date so I can help you in plenty of time for you to have the most success possible on each assignment. Chapter 4, Legal Elements and Their Impact. The key concepts in this chapter go over the different types of legal systems throughout the world, regulations and regulatory organizations to be aware of whenever you're doing a marketing plan, some basic legal terms, and also we will end just by talking a little bit about how all of these things impact your marketing efforts. The main legal systems in the world fall in mostly three categories. Civil law and common law are the two most common. Religious law is a third one you'll find throughout the world, especially in the Middle East, Sharia law being a prime example. Civil law is a system of laws in a country in which the country attempts to codify or write down all the laws that impact everything, from the way business is done to how people interact with each other or even how the government interacts with private organizations or individuals. Common law comes mostly from colonies of the British Empire and the countries that resulted from British legal systems. Common law is more of a system of understanding law through a series of court interpretations where people have brought their disputes in front of a judge and the judge determines what the outcome would be. Common law is based off of precedent, so a pattern of laws or a higher court determines, based on a certain set of facts, what the law should be. This always keeps things open to interpretation for anybody who might have a dispute, as they have to comb through all the different cases to see which cases match the facts of their own, so that they could probably pretty much guess how the judge might decide, but then once they bring an issue to court, they're never really certain that the judge will interpret things the way they will. In civil law, there are many cases where the law is written out very clearly and a court wouldn't even hear a case because it would just say refer to this law and this is the way we would decide the case, and there's no reason to bring this issue forward to the courts. So they are very different, and as a marketer, international marketer, you should be aware of what country you're doing business with and what their legal system is, because you may find that you think you might have a claim or a dispute that you interpret a certain way, but in that type of a legal system, there will be no day in court for you. Whereas in a common law system, there could possibly potentially be. And another thing to consider is private law versus public law. In every nation, there are systems of private laws or public law. Private law are laws that are created to settle disputes between two individuals or private organizations where there is no government entity involved. And contracts in business are a prime example of This, when two private companies or individuals engage in a business relationship, there will be sets of laws that help regulate and or determine any disputes that might arise. Public law is any time the government is involved in any type of case or dispute with a private individual. So any type of penal law or penal code where someone is committing a crime, that case would make its way through the court as the individual against the government or the government against the individual. Civil rights litigation might be another example of that. In each case, the impact on any marketing plan might be that you would really have to look toward private law to settle any contract disputes, and you would have to look to the nation's public laws to settle any type of crimes that were committed against you as a individual doing business or against your organization or company for doing business, such as crime or bribery or embezzlement. Those things we'll talk a little bit more about later. Another distinction to look for while you're doing business across the world is it an adversarial or a non-adversarial legal system? Typically, civil law countries tend to have non-adversarial systems, whereas common law countries tend to have adversarial systems. Adversarial systems are where when a case goes to court, each side gets to argue their best case, and the judge is more impartial and passive, and often there's a jury that is the decider of fact. The jury will decide what's true or not true. Each side gets to say whatever they want to say that they feel is the best argument or their best case to put forward. The judge is there to just determine any evidence that should not be admitted or any time that the laws are not being recognized throughout the process, because the idea there is that everyone should have their day in court and everyone should have a fair process. In a non-adversarial system, the judge is more involved. The judge asks questions. All the parties involved, their main focus is on seeking the truth. So the judge will ask questions of each side to push to see in what areas there's common agreement, in what areas there might be a difference of thought on each party, and then the idea there is to seek through mutual questioning and some probing what the actual truth of the matter is. So it's slightly different situation, and it's just good to be aware of when you're walking into different systems what your responsibilities as an organization or individual might be. As I discussed earlier, religious law is not as common throughout the world, but it is becoming increasingly more common in the regions of the Middle East, sometimes countries in Africa, and even within countries like the United States, there are some systems in which you will find religious law could come into play, particularly if you're doing business with a private entity like the Catholic Church, for instance. If there was a dispute that needed to be settled, they may follow canon law or have some sort of system set up inside of their own governing bodies that would decide how to settle those disputes. Socialist law is typically found in countries that are former communist countries or former Soviet bloc countries, in which the legal code is designed to uphold socialist ideas. Those are becoming more pluralistic, which is the last term at the bottom here. Pluralistic system means there's a combination of all of the above, and most systems throughout the world sort of have a combination of all of the above here. So it really is incumbent upon you to understand what the mix is in each country, particularly if you are signing contracts, doing business for the first time especially, and or if you come into conflict in any way with a person you're doing or an entity you're doing business with, you really have to understand the mix of all of these different systems that is unique to each country. And the last term that I have not covered yet here is administrative and constitutional law. Those are both examples of public law. So administrative law you would run into anytime there was legal regulatory agency that was started by the government at the national level. An example in the United States might be the Food and Drug Administration, which is run by our executive branch, or at the national government level, and funded that way as well. So there are laws that are similar to civil law and administrative law, where everything that you can and cannot do is listed out. And constitutional law would be areas in which there is specific provisions set forth for how government should function and what branches of government do what, or what levels of government are responsible for what decision making. So again, using the United States as an example, our constitutional law provides a separation of the branches and checks and balances on the branches, where the executive, the legislative, and the judicial branch each have their own responsibilities, but they each have a check of power against another branch. And there's also a federal system in which there are some areas in which the states, individual states, have their own power to make laws to govern their own people, especially when it comes to areas of public health and public safety. States are mostly still in charge of writing whatever laws they want, unless they create laws that are unconstitutional, which is then would be appealed to a federal court to be looked at by a judge on a federal bench to see if there's any U.S. constitutional violations. So again, every country has a mixture of how these types of disputes and which forms you would bring the case would be dictated by. And this is just a reminder to tell you that there are supranational organizations like the United Nations. Those are entities that come about because countries decide willingly to enter into these governing bodies to help settle disputes. And that has some benefits because it helps create stability. It helps create a feeling that if a dispute arises, that there is a set of laws and a system of laws in which you could reasonably predict the outcome will be aligned to those laws set forth by that governing body. Regulatory agencies created within a nation, however, are things like, in the United States, the Federal Trade Commission, which would regulate truth in advertising laws, or even safety standards like the FDA, the Food and Drug Administration. There's also the Foreign Corrupt Practices Act in the United States, in which it outlaws bribery as a legal form of a way of doing business, which didn't actually occur until the 1970s in the U.S. So surprisingly, in some countries, what we would call bribery is actually not illegal at all and is customary part of doing business. So these are things to be aware of. Some countries and nations have laws against these things, and some do not. So those are things to be aware of. And again, the World Trade Organization, which we discussed last week, is another supranational organization which, if a member nation wishes to conduct international trade and they wish to have any disputes, they might come into a dispute with another nation. They would take it to the World Trade Organization, but this is only the case for if they're doing business with another country that is also a voluntary member of the World Trade Organization. And this can actually be the deciding factor for a lot of companies and people doing businesses. If your country is a part of the World Trade Organization, you would have, again, some sense of stability that if you do get in any dispute, there is a governing body that will help settle that dispute, which is not the case for every nation. Crimes that are part of doing business and come up, especially when you're dealing in countries that have a high level of corruption, would be bribery, embezzlement, fraud, and extortion. Bribery, as we just discussed a little bit earlier, is when someone would give you money to court favor with you. So they may give you a little money on the side and say, hey, if I give you extra money on the side to you as an individual, you make sure your company approves the contract over my competitor. Embezzlement is when somebody is inside of your organization and funneling money away from your organization illegally. That can happen if you have to set up an international presence somewhere, someone within the country in which you're doing business